Good afternoon, everybody. My name is Jeff Newby, and we're here today to bring you to the WG University and our series of educational programs. And this is our workers' compensation webinar series. And today I'm joined by Renee Parada-Frazier from our Pittsburgh office. Renee drove in last night. Thank you very much for doing that for us.
Thank you.
And each month we do present a topic in workers' compensation legal issues. We present both case updates and ways to manage your risk in your business. If you'd like to see this webinar again, or share it with others, or see our WG University programs, please visit the Weber Gallagher website at www.wglaw.com. A lot of W's. And you'll find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions, and that's at questions@wglaw.com. So you can ask questions during the webinar, but please feel free to send them to us, and those questions will be filtered to Renee and I, and we'll get back to you as soon as we can. So today's presentation is considering Medicare's interests, conditional payments and set-asides, and specifically with respect to New Jersey workers' compensation. Next month, our topic will be the potential trouble zone, how to manage the intersection of workers' compensation, ADA, and FMLA issues. So let's get started with the Medicare issues that we're going to be talking about today. And before we talk about the specifics in dealing with your workers' compensation cases, let's just go back a little bit to where this trouble, I don't know if trouble is the right word, but where this speed bump all began. Back in 1980, the Medicare Secondary Payer Act was passed, and under the statute, Medicare will pay medical providers subject to later reimbursement from third-party proceeds from a settlement, a judgment, or an award. And those payments are known as the conditional payments. The Act deals with the issue of who's primarily responsible for the payment, and that's why it's called the Secondary Payer Act, because Medicare is the secondary payer to health insurance plans, liability insurance, self-insurance, and workers' compensation. So they will pay, similar to how PIP pays if there's a denied workers' compensation case, but in this regard, it's Medicare who's paying a medical bill that they say somebody else is responsible for. They'll pay it, but they want to get reimbursed at the conclusion of the case. So that's back in 1980, and what's happened is the Medicare Secondary Payer Act has been kind of updated, and the dust has been taken off that old statute from 1980, because the idea is that, the federal government, and we all want to keep Medicare viable and funded, and they want to make sure that benefits are not going out to the wrong sources or in the wrong case. So, for example, in 2002, the SMART Act was passed, and that was signed into law by President Obama, January 2013. And that was designed to explain, clarify, and strengthen Medicare and the repayment efforts, and sort of to redouble those efforts.
Yes.
To try and prevent bankruptcy, which is understandable. When each one of us becomes Medicare eligible, we want it to be a viable entity and not bankrupt so that it can pay some of our medical bills.
Certainly.
So Renee's going to talk to us about the impact of Medicare on settlements in workers' compensation setting.
Thank you, Jeff. Yes, in a workers' compensation settlement, Medicare has certain rights. The right to be reimbursed for conditional payments that they have made, and the right to be protected against future exposure for medical expenses associated with a work injury that are the responsibility of another entity being charged to Medicare. The conditional payments deal with the past, what has already taken place, and then we're also looking at the Medicare set-asides, which deals with future coverage for Medicare beneficiaries. Now, some of the questions that you need to consider are, have you checked to secure the conditional payment information, and do you need a set-aside, or is this a case in which you do not need to set aside anything for future medical? So, one of the questions is, when does Medicare have a direct impact upon the settlement of a New Jersey workers' compensation case in terms of the conditional payments? Well, this seems rather self-explanatory, but it is something that we have to take into account. Conditional payments only apply when the petitioner is a Medicare beneficiary. If the person is not already a Medicare beneficiary at the time of settlement, then Medicare would not have paid for any benefits related to the work injury prior to the settlement, so there would be nothing to reimburse. Now, conditional payments are payments that Medicare has made for treatment related to the work injury. and would otherwise have been the responsibility of the workers' compensation carrier or employer to pay, but for whatever reason they were not paid. The reason they may not have been paid may have been that it was a disputed case, or it may have just been a situation in which medical treatment was billed to Medicare rather than billed to the workers' compensation carrier. So one thing I try to emphasize is just because you may have already had from the beginning an accepted case does not mean that you don't really need to worry about conditional payments, because things could have still been billed to Medicare even if nothing was being denied by the workers' compensation carrier, simply due to a clerical error in a doctor or hospital's office. So that's something to always take into account regardless of the accepted status from the beginning of the case.
And we see that happen often in New Jersey workers' compensation. And when the petitioner is on the stand, oftentimes the attorney and the judge remind the petitioner, when you leave the doctor's office, more often than not, it's the family doctor.
Yes.
The family doctor's staff will take their Medicare card, and if they complain about their back or their elbow, that's the work-related condition for which they're receiving authorized care. The staff member may just put it through and the doctor's not paying attention. That's not what the doctor does. And
Exactly.
It goes through Medicare. Medicare may pay for an updated lumbar x-ray or medication for the back or the visit and categorize it as an updated evaluation for the low back issue. And it should have been deemed, it should have been through an authorized provider, not through the family doctor.
Yes.
But now we have a conditional payment that we have to deal with. And remind the injured worker, don't put anything through Medicare that's work-related. You've got to stick with your authorized doctors.
Exactly. And I often tell people to remember that when you're going for treatment for the work injury, make sure that you have the information for your workers' compensation claim with you. Oftentimes we'll see situations where a person goes to get treatment. They may not have the information for their workers' compensation claim with them at the time they get the treatment, and therefore the doctor's office not having that medication or not having that information may bill Medicare even if they know that it should be workers' compensation. So that's something that you have to consider even if it's always been an accepted case. Another thing that we have to take into consideration is whether the petitioner has a Medicare Advantage plan and whether that Medicare Advantage plan may have paid for treatment related to the work injury. Medicare Advantage plans are plans that are administered by a private entity, but they are only open to individuals who are Medicare beneficiaries. Because they are actually administered by a private entity and are a separate health insurance plan, those payments made by Medicare Advantage plans will not show up in the conditional payment investigation. So in addition to asking the petitioner whether they have Medicare coverage, we also need to inquire as to whether they may have Medicare Advantage plans, because we also have an obligation under the law to reimburse those plans as well.
I haven't seen this occur that much, thank God. More often than not, does the injured worker know that they have a Medicare Advantage plan as opposed to a Medicare benefit?
That's actually something that we're trying to help to educate petitioner counsel to, so that they can actually, what I like to do when I'm working on the Medicare aspects of a claim is I will ask to have petitioner send to me a copy of their, quote, Medicare card, their insurance coverage card. Through having them send me a copy of that, I have discovered that the person does have Medicare, but may also have a Medicare Advantage plan.
Is it noted on the card?
Yes, because
okay.
it will be through a separate private health insurer. They will have the Medicare Advantage plan. So they may think that they're just using their Medicare card when in fact they have this private additional health insurance as well. So we have to take that into account, and we have to inquire as to both. I had a recent situation where a person did not realize that they had a Medicare Advantage plan. When I contacted them and sent them paperwork to have them fill out their Medicare number, when they wrote the number on the plan, it was not in the format that Medicare uses for a Medicare number, which is tied in at present, although this is changing. At present, it's tied in with their Social Security number. When I received the number back from the petitioner, I recognized that this was not a Medicare health insurance claim number. This was similar to what you would have with a private health insurance coverage, and that way we were able to follow up with them and determine that in addition to Medicare, they had the Medicare Advantage plan.
Okay.
So that is something separate, although we do have the obligation to reimburse them as well.
Great. Can you tell us about that change in October 2015 that it seems like a lot of our clients have been slow to grasp, and we've had to point it out to them. I've tried to find the statute, and I'll steal from one of your emails or memos and send it to the client about October 2015 and who's responsible for this search.
Yes, beginning in October 2015, Medicare decided to go with a workload redistribution. And so what they did is for those cases that are accepted liability cases, most workers' compensation cases, they have shifted the conditional payment investigation from the Medicare Coordination and Benefits contractor over to the Commercial Repayment Center. In cases that are assigned to the Commercial Repayment Center, Medicare is looking to the carrier as the primary payer. In those situations, it should be the carrier following up with Medicare in order to obtain the conditional payments. There are limitations on the amount of information that petitioner's counsel can receive through the Commercial Repayment Center with cases where Medicare is looking to the plan as the responsible reimburser. Now, in some cases where there's already been communication with the prior contractor, Medicare has advised that unless you receive communication indicating otherwise, those cases that are already in the system prior to October of 2015 are staying with the original contractor. So your communications should continue along the same lines as they were previously. One issue that we see arising quite a bit are cases where there has been no acceptance of liability, and they are denied cases, and now we're looking at a Section 20 settlement, and we're trying to get conditional payment investigations begun. In those situations, really anyone can report the work injury to Medicare to initiate the investigation. What we're getting the feedback on, though, is that even in those cases where there's been a denial, petitioner's counsel are also very limited in what they're able to get from Medicare. So in order to expedite the process, we recommend that the carrier also communicates with Medicare to obtain the conditional payment investigation, even in those denied cases.
Practically speaking, if there's adjusters either from carrier standpoint or from a third-party administrative standpoint on the line today and watching the video, how do they reach out and communicate with Medicare and say, open up a line of communication with me, I've got this file? I guess when they find out that the injured worker is a Medicare eligible recipient, to get that conditional payment information streaming to them. How does that practically happen?
Well, what they can do is they can follow their Section 111 reporting protocols that at this point most carriers have in place. It's either alerting an in-house department to make the report through the Section 111 reporting, or if they have an outside vendor that does the Section 111 reporting, they can ask them to do so. There's also the ability for someone, either the carrier directly or counsel or the Section 111 reporting entity, to contact the Medicare Coordination and Benefits contractor via telephone, and they can make the report that way. If you go on the Medicare website, it provides you with updated contact information for the various contractors at Medicare, and right now they have the number that they've had for a period of time, but that does change over time, so you would want to make sure that you have the most current telephone number, but you can make the call through Medicare, and that's something that we've assisted our clients in doing in those cases where it's a denied claim, but we're trying to get the conditional payment investigation started.
Short of the phone call, like is it a, I know it sounds silly for me to ask the question, but I never get involved in this, you do. Is it a fax or a letter that the adjuster or their vendor sends to Medicare with some kind of a Section 111 form stating, we have this individual who's Medicare eligible, please send us conditional payments as they arise?
Well, most Section 111 reporting is done electronically, and each carrier has a different mechanism for that being done. There are certain things that must be included in the Section 111 reporting, and I have seen some carriers where they have the individual claims handlers inputting all of the information directly onto the preset forms. I have other carriers who have explained to me that their system is once they click on a icon indicating that the person is Medicare eligible and it's something that should be a Section 111 reporting, they have a system that will simply gather the information and input it, and then either they or the Section 111 responsible reporting entity will review it and send it over.
Is there a section on there, again, a question, I never do these, where they ask for the diagnosis? Because, obviously if we're dealing with a lumbar strain and sprain and not the cervical injury, which has a prior fusion, and we think they didn't injure their neck, is there a section that also asks for the diagnosis so that they send conditional payments that only relate to that part of the body?
Yes, in both the Section 111 reporting and in the direct reporting to the contractor via telephone, you advise them what the injury description is. And you can do a verbal description of the injury and also the ICD-10 codes.
Okay. I won't ask you any more questions, at least for now, but I'm gonna learn something today too. So let's talk about conditional payments. And conditional payments, they're different in every state. And Renee and I have been talking about this over the last couple of days. And Renee's becoming a pseudo expert in New Jersey workers' compensation as a result of dealing with some of our cases in New Jersey, because it's a different animal because of our statute and the way benefits are paid and awarded, and we can have applications to review what was, we thought, a prior settlement. So let's talk about conditional payments. They have to be investigated for any settlement with a Medicare eligible petitioner. So we've already established that. In an order approving settlement version of the settlement, you can close the case and settle the percentage disability, and that's what an OAS is, an order approving settlement, with a rider if you don't have the final conditional payment numbers. What does that mean? That means if we agree to pay 20% of partial total for the herniated disc in the lumbar spine, and we've written to Medicare, and we had to have written to Medicare, either ourselves or maybe if somehow Petitioner's Council has that pipeline through the Section 111 reporting, as long as there is a file open with Medicare and we can give a file number to the judge will allow us to settle the case with a rider that says if there's a Medicare conditional payment lien issue that we cannot resolve amongst ourselves, the judge has jurisdiction over the case. One party or the other can file a motion and bring that case back in front of that judge on that issue, and the judge can decide who's responsible for reimbursing that lien, or if either of us are. Because if Medicare is not giving in, not that the judge can tell Medicare what to do, but sometimes they can help us negotiate or give us a strategy to get around a lien that we think is inappropriate for one reason or another. So we can settle a case without final conditional payments in an order approving settlement because there are reopener rights. Medical benefits are not being foreclosed in the future. The injured worker can continue to treat with authorized physicians if necessary, reasonable, related, and all that kind of stuff. So because we're not closing out future medical, the judge will allow us to settle the case without a final conditional payment number. That is not the case with a Section 20. Under Section 20, that says a section of the statute, the judge actually loses jurisdiction over the case. The case is settled with prejudice. It's a final closed deal. They could paper shred the file. And neither side really has the opportunity to file a motion on that case to get in front of the judge again. The judge would say, Section 20 this case, I agreed, I approved, 10,000, 15, whatever the dollar figure is, and I no longer have jurisdiction over your medical bill issues. You should have resolved these before the case settled. That's why conditional payments have to be finalized prior to a Section 20 settlement. And we have some cases right now that are being delayed. We have a number, we've agreed to it, but Medicare hasn't gotten back to us with a conditional payment number. Until they do, we can't close and finalize that settlement.
One thing I did want to mention with the orders approving settlement, because you are not closing out without a reopener right the medical portion of the claim, Medicare will view that as a partial settlement, and there is still the possibility that after the date of the order approving settlement and prior to either expiration of the reopener right period or a subsequent Section 20 settlement, Medicare could still pay for treatment that would then become a conditional payment if it is found to be related to the work injury. So in terms of a final conditional payment number in an order approving settlement, what you would be getting is a final number as of that date. So just so that the record is clear that there could still be conditional payments after that date if the reopener rates remain.
Right, and that's part of the speech that the injured worker gets while they're on the stand. They're getting that 20% of partial total for the lumbar spine. They're being told by their attorney, if you need further treatment, you need to get it authorized. If their attorney doesn't give them that speech on cross-examination, I remind them, do not seek treatment on your own in an unauthorized fashion. Don't seek treatment and have Medicare pay for it. If you want treatment for this elbow, this back, or this neck that we're buying, it's compensable, it's our case. You've got to get it authorized by our physicians. Contact the carrier, contact my office, your attorney will arrange for it. So we try and prevent that from happening, but it's not fail safe.
Yes, as we discussed earlier, it could simply be a clerical error by the doctor's office as well. So.
And the last note we have on this slide on the PowerPoint is make certain to check that the conditional payments are related to your claim. And we can't emphasize that enough. We'll get 5 pages of bills, and you have to go through the coding and sometimes you have to get the records themselves that correlate to the bills if you don't have them, to make sure that they are causally related to your claim. Because if they're not, you can not so much negotiate, but dispute the bills with Medicare. And if you dispute them properly and point it out to them, I have seen liens from $30,000 of conditional payments come down to $10,000.
Yes, and in addition to making sure that the conditional payments are for treatment related to the work injury, you also want to make sure that the treatment has not already been paid through the workers' compensation carrier, either through subsequent discovery that the treatment should have been paid and payment, and then Medicare just has not updated their records and received reimbursement from the doctor, or through, again, a clerical error where the doctor's office may have billed both the workers' compensation carrier and Medicare, and for whatever reason receive payment from both.
Okay, and that's why it's important, and I always share the conditional payment lien, the chart, the individual bills with the carrier and the client so that they can go through it line by line. We'll do it if they would like us to do it and get the supporting documentation and contest it if necessary.
And I found that in conditional payments, if there's a question as to whether or not something may be related, they may have multiple diagnosis codes for a particular treatment, one of which may be related to the work injury. Keeping an open dialogue with claimants and claimant counsel can assist in situations where the person may have been treated for, let's say, a heart attack, but at the time they were treating for the heart attack, it was noted that they were having back pain, which is our accepted work injury, and so the diagnosis for back pain appears in the medical records. We may not know why the person was receiving treatment at that time. We may not have the records for that. So by keeping an open dialogue with claiming or petitioner counsel, you can have them help you to obtain records that you may need to dispute the claim.
Okay, and that charge.
Yes.
Okay. We're going to move on to the MSA portion of how Medicare kind of intrudes into our cases. So that's the discussion on conditional payment intrusion with a Medicare eligible recipient. The MSA portion is the future medical issues, whether or not we have to set aside money for potential future treatment that Medicare doesn't want to pay. They want the injured worker to pay for future medical that we're trying to get out from under. So, Renee, tell us a little bit about Medicare set-asides.
Okay, unlike conditional payments where the person needs to be a Medicare beneficiary for it to apply, Medicare set-asides apply even if the person is not a Medicare beneficiary. What I mean is you may have a situation where the person is not yet on Medicare but has a reasonable expectation of Medicare eligibility, which we will get to what constitutes that later today. But the person may be still within Medicare's review thresholds to not only have a set-aside, but have a set-aside that Medicare is willing to review. So what you need to do is you need to look at every case in terms of whether or not it is necessary to set aside something for future medical treatment in terms of a set-aside, whether it will be reviewed by Medicare because the thresholds are met or whether it won't be reviewed by Medicare because the thresholds are not met. What a set-aside does is it provides funds for payment of medical treatment into the future that otherwise would be paid by Medicare if it were not for a work-related condition. Now, under New Jersey law, this only applies to Section 20 cases because those are the only cases in which you are actually resolving the future medical portion of the claim. Now, what are the cases that Medicare will review? Medicare review, first of all, is voluntary. However, it is considered best practices and is recommended for those cases in which the review threshold is met. there are two separate review thresholds. The first review threshold applies for individuals who are Medicare beneficiaries. For anyone who is a Medicare beneficiary, the review threshold is any settlement exceeding $25,000. If the person is not yet a Medicare beneficiary but does have a reasonable expectation of Medicare eligibility within 30 months of the settlement, then the settlement meets Medicare's review threshold if it exceeds $250,000.
Fortunately, we have very few of those cases in New Jersey. You may have a few more of those in Pennsylvania, but we don't have too many that are over 250.
We do see a bit more of those in Pennsylvania than you do in New Jersey. So when does a person have a reasonable expectation of Medicare eligibility within 30 months of the settlement? One of the most obvious is if the person is age 62 and a half, because Medicare eligibility age in the United States is still 65. Another way that a person has a reasonable expectation is if they have applied for Social Security disability. In a case where a person has been granted Social Security disability, they will begin receiving Medicare coverage 24 months after they begin receiving Social Security disability. The Social Security disability begins 6 months after they have been found to be disabled under the Social Security statute. If the person has not yet received a decision on their Social Security application, or if they have received a decision and either have appealed or are still within the time frame to appeal the decision denying their application, they do still have a reasonable expectation of Medicare eligibility within 30 months because they could still become Medicare eligible. And the time frame would date back to the date that they were found to be disabled. We also have situations where a person can be Medicare eligible because they suffer from end-stage renal disease. Honestly, in workers' comp cases, that is not something that we see very often.
Those prior factors that you pointed out, Renee, 62 and a half, applied for SSDI, no decision on appeal, etc. That's an and. That's and $250,000 settlement.
Correct.
Okay.
Yes, both of the thresholds are and.
Okay.
Now, the dollar threshold, how do you get to the $25,000 or the $250,000? Medicare looks at the amount that is being paid as part of the settlement. They also look at amounts that are paid in past settlements. In New Jersey, they would be looking at what had been paid in any previous orders approving settlement prior to a Section 20. Another thing that you have to consider is if you are using an annuity, some type of structured settlement in order to fund the MSA, you don't look at how much you're paying for it. You look at the actual value of the structured settlement, the annuity. How much will the petitioner receive over the life of the settlement?
And when you say the annuity funding, you said MSA, you meant the settlement itself. So if we structure a Section 20, it's what's the cost of this structured Section 20 settlement?
Correct.
Okay.
Yes, you can structure the entire settlement or you can structure any portion of it. Any portion that is structured, particularly if you use an annuity because you're going to be paying less for the annuity than the person is going to be receiving, you look at how much is going to be paid to the Medicare beneficiary, the petitioner, over the life of the settlement.
Okay, so it's the value, not the out-of-pocket expense that's incurred by the carrier. Okay.
Yes. And as we know, that can be a significant difference.
And you and I, we were going to talk about, the amount paid issue, because we had a case a few years ago in New Jersey where we had the claim settled. The individual received a certain amount of money under an order approving settlement, and they filed an application to review within the time frame, and I was able to settle it and reach a tentative settlement under Section 20, which was less than $25,000. But when we added the money for the Section 20 to the original settlement, it was over $25,000.
Yes.
So I went to my judge and said, I think we need, I think the first time we tried to get around it, and this was a few years ago, and the judge said, no, I think you need to get MSA to approve this, because if I add the two settlements together, it's over 25 grand, so go to Medicare.
Yes.
So client retained Renee, you prepared all the documentation, summarized it clearly to Medicare, and said the first settlement was, let's say, $17,500. This settlement is $20,000, so it's $37,500 total. So we think you need to approve this $20,000 settlement. And we tried multiple times to get it through to them, and they wrote back to you multiple times and said, you don't need to come to us. This is under 25 grand.
Correct. That did occur. And what we actually did in that case is we actually sent to them both the prior order approving settlement and the proposed order. The judge was very nice in providing us with the proposed order that he was going to be issuing for the Section 20. We supplied both of those to Medicare with additional information provided by the judge so that he was certain that we were explaining it very clearly to Medicare, and Medicare still came back and said for whatever reason, they were not considering that first settlement to be a settlement in terms of the calculation. I can tell you every other case that I've had where there's been a prior order approving settlement and then a Section 20, Medicare has looked at both of them for whatever reason. With that one case, they were determined that it was not.
Didn't meet the threshold.
That it did not meet the threshold, that it was not to be considered for part of the settlement, so they would not review it. But
so I brought our efforts to the judge's attention. He said, you guys have done everything you could do, yeoman's job, let's settle the case.
yes.
And heck with that. So we tried. Let's talk about some issues where we may not have to deal with a set-aside. The first exception where I have future medical is not being settled, I might as well say, again, order approving settlement, or OAS, the acronym. That's the settlement where they have reopener rights. They can continue, they can treat with authorized doctors, they could get temp renewed if their knee needs another surgery, things of that nature. The second one, the claimant does not need further treatment for the work injury. That's great, but it's a tough one to achieve, because normally what that means is both petitioner's expert and our expert agree that there's no need for further treatment for the injury. It could be that they're alleging increased loss of function so that they could get an additional award of permanency, but both sides, for whatever reason, agree nothing more can be done to treat the injury. Nothing curative, nothing palliative that would prevent them from decompensating. So it's rare, but it could happen. And we can also seek a $0 set aside in a disputed case where there's been no past payment of benefits. And we do this fairly frequently, doing it now with a Medicare eligible recipient, and it's less than $25,000, Section 20. So we're looking for conditional payments, but we're not going to set aside any money. And we'll put on the record why we're not setting aside any money. We'll consider Medicare's interest, and considering their interest, they're going to get zero. So we're not setting aside anything for you for this denied ankle sprain or whatever it may happen to be. But we'll need to put something on the record, yes, why it is we think that a zero is appropriate, so if Medicare challenges it later on, they'll see the explanation we put on the record.
Yes, and I'm very happy that you mentioned the fact that you want to include that language and always consider Medicare's interest, even in those cases where the review threshold is not met.
All right, yeah, if it is a Section 20 and they're Medicare eligible. Short of that, I wouldn't put that language on there. Section 20 with a non-Medicare eligible recipient and no expectation, etc. I don't think that's necessary. So again, what if we have a case that does not meet the Medicare threshold? So we're under $25,000, and as Renee likes to point out and remind all of us that she helps handle these issues, thresholds are not safe harbors. So even though it's below 25 grand, we still need to consider Medicare's interests. So the parties to a settlement below the threshold still need to have some consideration for Medicare's interest, and that could include setting aside money under an MSA for a case under $25,000 that hasn't previously settled, but we can set aside money and not necessarily seek CMS approval. Can you tell us how that works?
Yes. If you don't meet the thresholds, either the $25,000 threshold or the $250,000 threshold, or you may have a situation where you meet those dollar amounts, but the person is not on Medicare or is not within a reasonable expectation of Medicare eligibility within 30 months. You would still want to consider Medicare's interests, and in some cases that would include a voluntary set-aside whereby a portion of the settlement proceeds are allocated toward future medical, with the petitioner agreeing to set those monies aside and use them only for treatment related to the work injury that otherwise would be payable by Medicare. In those situations, you want to consider Medicare's interest because the person is expected to have treatment that could exceed the period of time before they become Medicare eligible. So at some point, the person could become Medicare eligible while they're still receiving treatment for the work injury. Even if it's a situation where it's not expected to have any future treatment and you don't meet Medicare eligibility, I would still include some statement on the record that you've considered Medicare's interest and the person does not need Medicare or does not need a set-aside amount because future treatment is not expected. However, you would not necessarily need to go through the type of set-aside analysis preparation that we would do for a case where you would be submitting it to Medicare.
And the amounts that you would set aside, I think that how do you come up with an amount that you propose in a case where you're not seeking CMS approval?
Well, there are different ways that you can do that. What you can do is you can look at just what the person's medical treatment has been over a certain period of time. If their treatment is stable, if nothing is really being proposed, then you would look at what are we paying on an average basis and then move forward based upon their life expectancy as to the allocation. In cases where there's expectations that a person may need extensive treatment such as surgeries or various assistive devices over the course of their life expectancy, you can do a more formal set-aside analysis of the type that you would submit to Medicare. We've also had some cases where we simply go to claimant or petitioner, claimant is the Pennsylvania term, petitioner's side and say, listen, you are in a better position than we are at present because this is a reopener in this case. We don't have a lot of medical records. What is your doctor saying about future treatment? And if you can agree that their doctor's anticipation of future treatment seems reasonable, you can go based upon what their doctor is recommending for future treatment. But you would want to have a medical basis for any allocation that you do.
Right. And I don't know that we really touched on it, but I guess the kind of glossed over the topic that in a Medicare set-aside situation, Medicare has said, CMS has told us, we don't necessarily need to approve your MSA.
Yes.
We'll approve it if you want us to. You'll have to wait till we get to it, but you don't have to seek our approval. So that's up to each of the parties, petitioner, defense, employer, carrier, whether or not they think that they can prepare an MSA which is appropriate and which would pass muster if it's reviewed years down the line. If everybody wants to sleep better at night and are willing to live with the delay, then you can seek their approval. And that's all for above threshold cases. Below
Yes.
threshold cases, then won't even look at it.
Correct.
Okay. I have some issues I wanted to run by you before we wrap up. And these are some of the issues that we talked about that I find a little bit frustrating from my standpoint, and you deal with them more often than I do. I'm trying to resolve some cases where, my injury is finite. It's like the knee, or right now I have an injury with the low back. And the vendor that's on the file is asking me to gather information that I don't really have easy access to, because I don't represent the injured worker, and the information they're requesting has nothing to do with my comp case, where the authorized doctors or my client carrier could be sending me the information if I just asked for it. For example, multiple years of pharmacy records. And again, this is for medications being taken for non-work related conditions, or perhaps prescribed by physicians that aren't authorized. And again, extensive medical records for non-work related medical treatments, a liver condition that they want to determine the life expectancy, for instance, separate and apart from the orthopedic injury. And so my question for you is if you could address those kind of roadblocks, or at least the additional investigations being requested oftentimes. Why is it being requested? And can defense counsel step out and introduce the vendor to the petitioner's attorney and say, you guys talk, because petitioner's counsel has access to this information much more quickly than I do. Take me out of the process because it's just going to slow it down a little bit.
Well, first of all, Medicare may be requesting these records, particularly in cases where we're seeking a $0 set aside, to just make sure that the petitioner is not treating with someone that is not being reported to Medicare for the work injury. So that's more of a secondary check to make sure that something's not occurring that we just don't know about and therefore are not reporting to Medicare. In some cases, the vendor may need those records because the person may have other conditions that, as you mentioned, may affect life expectancy, and therefore we need that information so that we can provide it to the vendor, and then the vendor can provide it to Medicare to justify why the person who may have a regular life expectancy of 45 years we're saying their life expectancy is 20 years. So we would need to justify that to Medicare. In situations where we're seeking medical records beyond records that we would have for authorized treatment or treatment related to the work injury, as long as the carrier authorizes us to have direct communication between the vendor and petitioner's counsel, I see no problem with that, because they certainly are the people who have that information more readily available to them than we do. One of the issues that I have encountered at times has been a reluctance of petitioner counsel to give authorizations to a vendor. In some cases, they would prefer to give authorizations to counsel rather than to the vendor, so as to ensure that any medical records obtained through those authorizations are provided to them. I've had other situations where the vendors reach out to petitioner counsel, and petitioner counsel may not be fully aware of what their role is, and therefore are reluctant to provide authorizations. In cases where there is a reluctance on the part of the petitioner to communicate directly, or petitioner's counsel to communicate directly with the vendor, what I have found helpful is to initiate the contact through mutual emails to both of them, and then indicate to both of them that they should copy us as defense counsel on the communications between them, so that everyone's aware of what's going on. If there is a delay in receiving information, we can reach out to whichever side needs to be reached out to.
Yeah, I don't like being the middle person in this, because I just get asked frequently by the vendor, what's the status of blank? And I have to go to the petitioner's attorney and say, where are these signed authorizations? Because there are certain releases that need to be signed
Correct.
before they send the submission to Medicare. And it just seems like it's a waste of an extra step that could be taken out. But the last two topics that we wanted to talk about today, let me see. Yeah, let's just jump ahead a little bit on like how to expedite.
Okay.
Suggested steps to expedite this process, because I think that's, in New Jersey, that's really what clients like to hear about, is how to expedite some of these closures, especially when you've reached the dollar figure and the case is just getting adjourned, in New Jersey speak, waiting for either the MSA or the conditional payment. So I guess let's go first to the suggestions to expedite the conditional payment search.
Yes. What I can indicate is the best way to expedite the conditional payment search is early reporting of the work injury. Whether it is an accepted work injury that is being reported through the Section 111 reporting, making sure that there's open communication so that as soon as a person becomes Medicare eligible, the carrier is aware of it and can get the reporting process started, or situations in which it's a denied claim, and those situations where petitioner and counsel can also be making the reports directly to the Coordination and Benefits Office.
And last but not least, how can we expedite the MSA process, the Medicare set aside, when we're doing a Section 20?
And again, one of the biggest things to do is keep the lines of communication open. Make sure that all the parties are communicating so that petitioner's counsel knows who the vendor is and feels comfortable with communicating directly with the vendor. Don't wait until the settlement is completed in order to begin the process. And by begin the process, I mean start to look at whether it's a case that will meet the review thresholds in terms of the person's Medicare eligibility. We may not know the number, but we can at least determine, okay, we have a Medicare beneficiary, or we have a person with a reasonable expectation, so that one of the $2 thresholds will apply to it. So we need to start gathering information now that will need to be submitted to Medicare. Another thing, when you're dealing with a Medicare vendor, they don't have access to everything we as counsel and the carrier and petitioner have access to in terms of the court record. They only have access to what is provided to them, so it's very important, if there's been any sort of change to the nature of the injury or to the treatment that is being provided. Situations where we may have a person who's, due to a slip and fall, suffered multiple body part injuries. However, many of those injuries may have resolved. prior to the time period for which the vendor is seeking records. If we have documentation that certain conditions have resolved, we will want to make sure that the vendor has that, so the vendor can say, yes, this was part of the accepted or claimed work injury. However, here is medical documentation that it has resolved, rather than simply saying, well, they haven't treated for this period of time, so we want you to apply 0 to it. They can actually say they haven't treated, and additionally, here's the medical documentation of resolution.
And I guess similarly, and we hadn't discussed this before, if we get information that they've sustained a subsequent injury to the same part of the body due to a non-work related episode or even work related but with another employer, again, we want to get that to the vendor and say they had a back issue they were treating. It kind of slowed down. Then they had a non-work related motor vehicle accident on vacation or driving to vacation, injured their back, they're treating again, etc. That's why this MSA has got to be a much lower number. And we give them that information as well.
Exactly. Anything that affects the nature of the injury or the medical treatment, outside of the medical treatment, the vendor is going to be relying upon us to get that information to them. So if you have a new injury or a different injury, anything that is going to impact upon whether or not that treatment is actually related to our work injury, you want to get to the vendor.
All right. Thanks, Renee. I've learned some stuff today, and hopefully everybody else has. Medicare, and that they're seeking reimbursement for conditional payments and set-asides. It's not going anywhere. It's not going to be going away anytime soon. In order to, as we said at the beginning, to make sure that it's never going to become bankrupt, that it's available for all of us. So we have to be as proactive as we can be to open up these lines of communication, to communicate and send out that Section 111 notification in a Medicare eligible
Yes.
Injured worker, and begin the process of MSA as soon as we can. Once we know that we're going to try in Section 20 this case, we can at least at that point begin to gather some of the medical records we know are going to be needed, even though we normally wouldn't be pursuing them because we know they're going to be asked for eventually anyway.
Yes.
So we'll do what we can to expedite these resolutions. But anyway, thank you for attending our webinar. The next webinar will be on March 21st, and it'll also be from the Philadelphia office. And the title is The Potential Trouble Zone, How to Manage the Intersection of Workers' Compensation, ADA, and FMLA. I probably will tune in for that also. Our Pennsylvania workers' compensation attorneys will be providing an overview of the cross-section among the requirements of workers' compensation and the ADA Act. This will also address how to troubleshoot when you are dealing with an injured worker, how to handle the worker when they're not released to full duty but have reached maximum medical improvement, and provide practical advice on a hypothetical employee situations involving workers' compensation, ADA, and FMLA, which they're all part of the pie, but they're different slices of the pie.
Yes.
And there's some of us are experts in workers' comp, some are experts in ADA and FMLA, and we'll have both together to give you all of those angles to give you some good advice. So you can learn more about this program and any other Weber Gallagher events at wglaw.com/WG/university. Thanks, everybody. Have a great afternoon.
Thank you.